Hello, welcome back to week 5 on fundamental rights. In lecture 1 in week 5, I covered the question, what rights do we have? I explored a typology of rights, the nature of rights of human rights in international law, as well as a broad outline of the fundamental rights in the Constitution. In lecture 2, we will explore 3 different topics. First, I will outline a political history of constitutional rights in India. We will then outline and spend a little more time in detail on the types of constitutional fundamental rights that we have. And I will conclude with a very brief sketch of how fundamental rights may be enforced, both legally and politically. So this is the coverage for lecture 2, and it's the last of the lectures in week 5. So let's get started. Many people consider fundamental rights in the Constitution to be a unique gift of the Constitution. That somehow fundamental rights found their way there, and this was something of a historical or political accident. Nothing could be further from the truth, because Indian debates and political movements around civil rights began very early in the 19th century. So we've been thinking and talking about this question for 2 centuries in Indian political movements. By the early 20th century, civil and political rights began to emerge as important demands of the freedom movement. After World War I, a further dimension gets added in that economic and social rights come to the fore of the demands of the national movement. Finally, in the decades leading up to the drafting of the Constitution of India, special provisions for minorities, the lower castes and women were agitated as being essential for the social and political transformation that India required. Finally, fundamental rights and directive principles in the Constitution of India 1950 capture this long history of agitation and concern with fundamental rights in the Constitution. So let's move on and begin in the early 19th century. So in 1895, the Constitution of India Bill, which was drafted by anonymously at the time, but seemed to be generated by some leading figures in the freedom movement, made an explicit demand for fundamental rights. The early demand was for free speech and protections against arbitrary imprisonment, as well as a free state education. Notice the broad swathe of demands. It's not just the normal civil and political rights against the criminal law excesses of the state, but the entire range of social rights, including state-supported education, as well as the liberty rights of free speech. So 1895, the Constitution of India Bill, which was produced by the freedom movement, is the first crystallized document where such demands for rights are made. In 1917 and 1919, the Indian National Congress, which was, as we've discussed before, an umbrella organization around which the freedom movement was organized, made demands for civil rights and equality of status between native Indians and the English. So you will notice that the early demands are made as demands seeking parity with the English. In 1919 and 1920, and this is all post-World War I, the Montague-Kempsford reforms and the Rowlatt Act come into being. And these generate fresh demands for rights protections. The 1919 reforms, for those of you who paid attention in your civics class, introduced a model of government called diarchy. But moreover, after World War I, the imperial state got far more serious about suppressing dissent and anti-colonial resistance, especially with Gandhi's Satyagraha around the same period. You see a far more stronger use of the criminal law to suppress dissent. What occurs in this period, especially after the Rowlatt Act, which was a egregious form of criminal law litigation, legislation, there is a shift in the demand from equal rights between Indians and the English to a demand for fundamental civil and political rights to Indians or to all those who reside in India. The tenor of the demand has changed in that period, 1919-20. In 1925, Annie Besant's Commonwealth of India Bill makes a broad set of demands, which starts resembling in some ways the Constitution of India as we now have it. These demands include individual liberty, freedom of speech, free assembly, as well as free elementary education and equal rights to public spaces. Now, this kind of wide-range demand is a precursor to what will follow, which is stronger and stronger demands for a comprehensive Bill of Rights. It is worth remembering at this point, even at this early stage, that Britain, in its domestic law, England, did not have a Bill of Rights instrument. As we all know, the English Constitution was famously unwritten, not set down in a single charter, and disavowed a rights declaration. That is an American instrument, legal instrument at that point in time. The English didn't use it in their own jurisdiction. So the novel claim that India must do this, that the English must do this in India, was subject to much skepticism, both for its novelty of form, a charter of rights enforceable by law, as well as the fact that imperial government could not tolerate such demands from the native people. In 1928, we get a strong document called the Nehru Report. This was Motilal Nehru, who was commissioned by the Congress to develop a document that could serve as, in some ways, a proto-constitution, but more directly, a declaration of fundamental rights. The language of fundamental rights can be traced directly to the Nehru Report, and that language continues all its way into the Constitution of India 1950, and a close reading of the Nehru Report would suggest that it anticipates many of the rights and phrasings that find its way into the Constitution of India. In 1931, the Karachi Resolution, which is a resolution of the All India Congress in Karachi, adopts a wide range, a broad platform, and the Karachi Resolution is worth reading for the nuanced and novel way in which it understands the relationship between civil and political rights on the one hand and social and economic rights on the other. So let me read this out to you, and it's worth reading and reading slowly. This Congress, that is the All India Congress in Karachi in 1931, is of the opinion that in order to end the exploitation of the masses, political freedom must include real economic freedom of the starving millions. In order, therefore, that the masses may appreciate what Swaraj as conceived by the Congress will mean to them, it is desirable to state the position of the Congress in a manner easily understood by them. The Congress therefore declares that any constitution that may be agreed to on its behalf shall include the following items, or should give the ability to the Swaraj government to provide for them. This dovetailing, this constant emphasis that civil and political rights standing alone would not have meaning unless they were accompanied by economic freedom and social freedom, is a strong position that is developed in the Indian freedom movement. Please remember that at this point in time, constitutional traditions, and let's just take the United States as an example, have not embraced the position that social and economic freedom must be provided for in a constitution. They are skeptical of that possibility. The Indian freedom movement goes much further ahead and provides for this possibility as early as 1941. In 1945, in the Sapru report, this not only is the fundamental rights and the economic and social freedom positions further developed, but we get a full account of the protection to minorities, religious minorities, and to the use of the courts as a mechanism to enforce these rights. So a full-fledged judicial protection of fundamental rights. Our next stop is the States and Minorities Report, which is compiled by the All India Scheduled Caste Federation, led by Dr. Bhimrao Ambedkar, and submitted to the Constituent Assembly. So it was oddly called the States and Minorities Report, but as you can see with the subtitle on the screen, what are their rights and how to secure them in the Constitution of Free India. And this was about the scheduled caste. What are their rights and how do we secure them? This particular document, the States and Minorities Report, resembles something like a mini constitution. It had a preamble. It provided for the admission of Indian states, the Indian princely states that we discussed in week 1 into the Union. It provided for fundamental rights of citizens, and it also expressly provided for remedies against the invasion of fundamental rights. It provided for the protection of minorities as well as safeguards for the scheduled castes. When we look at this document, and we know that it's just very close to the dates on which the Constitution of India begins to sit, the Constituent Assembly of India begins to sit to draft the Constitution of India, we notice that we have a proto-constitution in shape, at least one that is fashioned by Dr. Ambedkar with the All India Scheduled Caste Federation. In around the same time, in 1946, Hansa Mehta, who was a member of the Constituent Assembly of India, as well as the United Nations Drafting Committee and the United Nations Subcommission, drafted an Indian Women's Charter of Rights and Duties through the auspices of the All India Women's Conference. The Indian Women's Charter provided not only for rights of equality, but also rights to education, health, and work. It has a striking phrasing of the right of women as homemakers, both a recognition that women played that role and the conferral of certain rights and protections on women who did play that role, as well as a focus on property, marriage, and family. Now, this kind of framing of women's rights finds its way into the Constitution in small parts, but maybe not as fully as could have been in that period. So, notice that you have documents drafted by the All India Congress, documents drafted by subcommittees of the Congress, documents drafted by actors like Hansa Mehta and Dr. Bhimrao Ambedkar, were not fully within the Congress system at that point in time. Finally, in the Constitution of India 1950, we got a broad set of rights as well as principles. The Constituent Assembly appears to have distinguished between negative and positive obligations of the state. Where the state undertook negative obligations, the rights were given the language of fundamental rights. Where the state undertakes positive obligations, the rights were called the the principles were called the directive principles of state policy. This distinction anticipates the debates in the international fora about the place of these two different rights. You will note that the Universal Declaration of Human Rights was adopted at about the same time, though the International Convention on Civil and Political Rights and the International Convention on Economic and Social Rights had not emerged, making this bifurcation between civil and political rights and social and economic rights very, very strongly. The Indian Constitution adopts this distinction in a slightly different way by creating two separate chapters: a fundamental rights chapter, which is part 3, and a directive principles of state policy chapter, which is part 4. We have in the picture a book that captures for you, for those of you who are interested in this history, a careful account of how the bifurcation of the two parts took place, and how we might read and understand the pressures that were on the Constituent Assembly as it split Part 3 and Part 4 at that point. So Part 3, and we can go over this one more time to emphasize and maybe better give better detail to that distinction. Part 3 of the Constitution ostensibly contains civil and political rights. But we do know that, as from lecture 1, week 5, that there are aspects of Part 3 fundamental rights that deal with social, economic and cultural considerations. Let's take a few. On social issues, we have the ban on untouchability. On economic issues, we have a right to education, the provisioning of the right to education, albeit by amendment. On cultural issues, we have rights for religious minorities, both to maintain their culture as well as to establish institutions. So notice in all these cases that the civil and political descriptor fundamental rights chapter of the Constitution, Part 3, seems to go beyond the descriptor. But what is critical about Part 3 is all of them may be enforced through the courts. They're legally enforceable. And this distinction is a sharp and notable one between Part 3 rights and Part 4 principles. Part 4 states a range of principles which are fundamental in the governance of the country, but not enforceable through the courts. I would take out that expression, not justiciable, because that's not the language of Article 37. Article 37 simply says that the principles laid down in Part 4 are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. So there is a binding state obligation, but not one that can be enforced by the courts. And this distinction between the model of enforcement and the nature of the rights has shaped Indian constitutional history right from the 1950s, right up until now. To call the principles in Part 4 of the Constitution socio-economic rights may be inadequate, to the extent that some Part 4 principles include a range of matters that are not just social and economic rights. For example, we know that a much discussed article in Part 4 of the Constitution deals with questions of the killing of cows. Now, one can make the argument that this is a social or economic right, but anyone who's familiar with that part of the Constitution will know that it's not structured either in the terms of rights, and it is focused on a very specific aspect, controversial political aspect of pre-independence India, which was regarding the place of cows in Hindu religious thought. Let's move on from Part 2, which is a broad political history of early conversations around rights, all the way into the Constitution of India 1950, to Part 3, where we will look quite closely at the core rights in this chapter. We look at one right that the Constitution of India granted in the 1950s and has come to be changed substantially. We want to pay attention briefly to who can claim rights and whether rights are absolute or relative. What rights do we have? This is the broad coverage in Part 3. And I encourage all of you to equip yourself with the bare text of the Constitution. Download a PDF. It's easily available on the India Code website. And use this as a companion to browse through these provisions as we discuss them in this section and elsewhere in this course. Broadly, we can break up the rights as rights relating to equality, life and liberty, and then equality and liberty. Now, we understand that rights are intersecting and often speak to each other. But in terms of organizing the rights, there are many ways in which we may choose to organize a discussion of fundamental rights. And this is just one way to help you begin that conversation. On equality, Article 14 guarantees all of us equality before the law and the equal protection of the laws. Now, these are very broad phrases, and we will spend some time unpacking what these phrases mean. But Article 14 is not the only equality article. Article 15 puts in place a prohibition against discrimination, so that there can be no discrimination on the basis of race, caste, sex, and other grounds. Article 16 assures us equality of opportunity in public employment, an essential requirement for a society where all may seek to participate in the structures of government. Article 18 talks about the abolition of titles. These are primarily targeted at monarchical and imperial titles, but have come to take on new meaning subsequently. And Article 18 was seen as an essential requirement of a republic, which was not a monarchy. Article 29, Clause 2, also puts in place an anti-discrimination provision with regard to educational institutions. I might add here that Article 16, Clause 2, puts in place an anti-discrimination requirement with respect to public employment. So let's look at the broad dimensions of the right to equality. First, statements, proclamations of equality before the law and equal protection of the law, as well as inequality of opportunity. And then second, and a requirement that there be no discrimination against on the basis of race, caste, sex, as well as other grounds in generally by the state, but also specially in the fields of public employment as well as public educational institutions. So that those are a subset of the equality provisions, protections that we have in the Constitution. The second broad type of protection we might describe as a life and liberty protection. The life and liberty protection is anchored around Article 21, which guarantees that we all have the right to life and personal liberty, and this cannot be taken away from us unless procedure established by law is followed. So you must have a law that can deprive anyone of life and personal liberty, and unless such a law exists, all persons are guaranteed this right. The state cannot tamper with it. Now that you have a foundational right to life, other rights get tagged on to it. The first I'd like to discuss is the protection from arrest and detention. This is an extension of the personal liberty protection. That is that once we put in place certain restrictions in the Constitution on state authorities as to how they might deprive your personal liberty, though you can't even make a law that goes against it. Article 20 puts in place some protections in the criminal law area against retrospective laws as well as some protections against self-incrimination. So we will discuss some of these laws, these constitutional provisions in greater detail. But notice the cluster. Article 21, which is a base life and personal liberty protection, and around Article 21, you have Article 20 on the one hand, which prevents the creation of certain kinds of criminal law, and Article 22 on the other, which prevents the state from exercising its criminal law powers in a way that infringes on life and personal liberty. Apart from these liberties, we have a range of other freedoms, and those are contained in Article 19 of the Constitution. The 6 freedoms of Article 19 include the freedom of speech and expression, as well as the freedom of movement, the freedom of assembly, and so on. And we will study them at greater length later in this course. Articles 25 to 28 cover a range of religious freedoms. Religious freedoms are odd in that in some cases the guarantees are to individuals, in the other cases the guarantees are to group exercises of these religious freedoms, And so one must be attentive to who is the claimant of the right in each of these cases. Finally, I want to deal with a cluster of provisions that we might call combinations of the equality and liberty principle. Let me start from the bottom. We have a range of articles, Articles 29 and 30, that put in place some freedoms for religious minorities, while at the same time requiring that they be treated in a manner that allows them to emerge and find full cultural expression in an independent India. So 29 and 30 deal with the problem of treating religious groups equally, while at the same time assuring them some freedom in how they might emerge. Article 24 and Article 23 deal with specific problems of the social sphere peculiar to India. The problem of human trafficking and forced labor. These were initially very closely tied to the caste system and then find later manifestations related to the caste system and beyond, as well as a prohibition on child labor. So for various reasons, the issue of child labor was significant and agitated in pre-independence India by the All India Congress, and it finds its way into the constitution, so that it's not simply an option left to legislatures. A prohibition is placed in the constitution. A similar provision with respect to caste is on the abolition of untouchability, Article 17. I discussed it briefly in the last slide. And the point of Article 17 is to ensure us equality, but to also prevent curtailment of the liberty of actors based on social practices like that of caste and untouchability. Article 15.2 continues in a similar vein as it tries to remove all disabilities, civil disabilities, that might attach to any person in their use of public resources and public spaces. Now, this body of provisions can't be understood purely as liberty provisions. They operate against backgrounds of social discrimination, which are expressly sought to be overcome by the Constitution, and in particular Part 3 of the Constitution. Let's turn our attention to the right to property for a moment. When we think and we talk in the language of fundamental rights, constitutional fundamental rights, there is a tendency to assume that once these rights are granted, that is, once these rights are written into the Constitution, they are there forever. Now, this would be a reasonable conclusion for someone to reach, but this is not the case. And let us look at one example. The right to property was placed in the Constitution in two different articles in the Constitution of India 1950. Article 19(1)(f) provided that all citizens shall have the right to acquire, hold, and dispose of property. Article 30 provided that no person shall be deprived of their right to property except according to procedure established by law. You will notice that Article 19, the right to property, is very similar to the other Article 19 rights of freedom of speech and so on, whereas the Article 30 right to property is very similar to the guarantee in Article 21 of the right to life and personal liberty. However, these strong constitutional protections of the property right ran into constitutional litigation almost from the get-go, from 1950. And the reason for this litigation is rather complicated. But if we take for a moment that the Constitution had adopted strong social and economic transformative goals in the Constitution and had directed Parliament and executive government to secure these goals, Parliament then started passing enacting a range of land acquisition laws and tenancy reform laws. And all of this was motivated by the need to redistribute land, a vital resource in production. The Supreme Court, when it was confronted with citizen petitioners who were challenging the right of the state to enact such laws, often found these laws constitutionally deficient and struck down these laws. What could Parliament do? Parliament immediately set about amending the property clauses of the Constitution. So, by the first constitutional amendment, which began this process in 1950-51, to the 44th constitutional amendment in 1978, the right to property was almost entirely taken out of the Constitution. It is no longer a fundamental constitutional right. It no longer is protected by Article 13 and Article 32, so it's not judicially enforceable. It is instead replaced by an Article 300A, a constitutional guarantee but not a constitutional fundamental right, that no person shall be deprived of their property except by authority of law. A tamer version of Article 30 is found in Article 300A. Why do I bring up this discussion? I mean, the right to property, in some ways, the history of Indian constitutional law and Indian constitutional experience can be told through the litigation and controversies arising out of the right to property. But the small reason that I placed this slide here today is to alert you to the fact that the right to that no fundamental constitutional right, even the right to property, is immune from change. If the majorities, the stable majorities in Parliament, and in some cases the states, feel that the constitutional architecture is preventing change in a manner that they seek, they may amend our Constitution, including in the Fundamental Rights chapter. So this is the range so while constitutional rights are fundamental and constitutional, they are subject to change. In our discussion around citizenship, I had briefly reviewed the range of beneficiaries of fundamental rights. We had discussed the distinction between citizens, persons, residents, and so on. So let's try and understand and locate who might be able to claim fundamental rights. The first and important general principle that we must appreciate is that all fundamental rights are not granted to all persons. So there is no uniform grant in Part 3 of the Constitution. Some fundamental rights are granted to all persons. For example, the right to life, Article 21, while some are available only to citizens. For example, the right to equal opportunity in public employment, Article 16(1). And some are restricted to specific groups. For example, Article 15(3) allows the state to make special provisions for women and children. Only women and children can take the protection of Article 15(3). So whenever we read a constitutional article, we must be attentive to who has a claim under this constitutional article. There is some doubt about whether corporations and companies, other legal persons, trust societies, can claim the benefit of fundamental rights available to citizens. And to this we must say that generally speaking, only natural persons can claim fundamental rights, but through some mechanisms of litigation procedure, companies may also seek to gain benefit, especially if one of their shareholders can claim to be particularly aggrieved by a rights violation. So this is the range of claimants, except the individual claims, except for group rights. And let's pay attention to group rights a little bit, so that we get alert to what kinds of groups and under what conditions can they claim rights. So different groups have been provided different levels of protection under the Constitution. There has been a recognition and protection to linguistic and religious minorities in Articles 26, 29, and 30. There has also been, as I just discussed, protections for scheduled castes. scheduled tribes, and other backward classes, as well as women and children. In this case, the state can make special provisions to benefit them. The aims and objectives for protecting every single group are very different. The protection of religious minorities occurs against the background of the adoption of a secular state, a point of distinction between India and Pakistan at the time of partition, but also a point of distinction between a secular and a theocratic state more generally. At a later point, the protection of religious, linguistic and cultural minorities was seen as essential constitutional protection, not only for religious groups, but also for minority language groups in order to protect their cultural vitality. The protection for special groups like SC, ST and OBC groups, as well as for women and children, are attempts to turn back historical disadvantage which has persistent effects into post-independence India. So the motivation for protection and the nature of protection for each of the groups is distinct and requires some careful historical understanding to help us along the way. I had spoken about for a moment that that fundamental rights in the Constitution, may be amended. But while they are in the Constitution, are they absolute? Should we think that when we have a right to free speech, that right to free speech must overcome all other considerations, restrictions that may be placed on my free speech right? Now, the Indian Constitution does not design an overall exceptions and limitations clause. Some constitutions, newer constitutions like the Canadian or the South African Constitution, have an exceptions or limitations clause where they broadly set out the circumstances under which a fundamental right may be regulated. But the Indian Constitution doesn't have such an omnibus clause. So how should we read the Indian Constitution? The first point that we might pick up is that some fundamental rights do have specific restrictions which are set out in corollary articles. For example, Article 19.1 has a corollary restriction in Article 19.2. And if you look at the small cartoon picture on your right, and you recognize the context in which these issues have arisen around the contempt of court, recent controversies on the contempt of court. 19 Clause 2 clearly provides for reasonable restrictions on the exercise of the free speech right in relation to contempt of court. So, in a contempt of court proceeding, if one is prevented from speaking, the Constitution anticipates that this is a reasonable restriction on free speech rights. Now, not all contempt type proceedings are reasonable restrictions, but the Constitution permits such a reasonable restriction to come in. Other kinds of restrictions are not expressly set out in clauses like Article 19 Clause 2, but may be read into a clause which at first blush looks absolute, but through judicial interpretation and application admits of some exceptions. Article 14, which guarantees to all of us equal protection of the law and equality before the law, seems to be one such absolute proclamation. What indeed occurs is that the Supreme Court of India has introduced the doctrine of reasonable classification. And reasonable classification allows us to not apply Article 14 in a binary, either it applies and strikes down the action or it doesn't apply kind of way, but allows us to build some nuance and some detail into how the equality protection of the Constitution operates. We will spend some time on that a little later in this course when we talk about the equality cases. Overall, we might understand that while citizens, persons, and groups are granted rights of various types, these rights taken together are ultimately likely to be balanced off against each other. This task of balancing and according appropriate weight to the rights is a complicated one, often left to the Supreme Court of India in the most complicated cases. But this balancing with the rights of others might best be done through a simple test like a proportionality test or a balancing proportionality test. But the Indian Supreme Court is yet to articulate such a test in a direct way. So we might imagine what such a balancing and accommodation perspective might be. So we move with the idea that not all rights are absolute, and though fundamental rights may be drafted in this broad sense, we should not make the mistake of assuming that they are absolute. While we all have rights that are clearly stated in the Constitution, do we have rights that go beyond what is stated in the Constitution? And that is the question that we ask in this slide. Are there unenumerated fundamental rights? Rights that were either discussed in the Constituent Assembly and denied, which we can now reassert, or rights that were never imagined in the early stages of the Indian Constitution framing, but we would now take to be standard rights. What kinds of unenumerated fundamental rights do we have? In the Maneka Gandhi case, which many of you might know, the Supreme Court of India took the view that the protection of life and personal liberty also included the protection to the right to travel abroad, a right which is not otherwise recognized in the Constitution. Even insofar as we have a right to free movement, it is only a right within the territory of India. So this right, which was generated in the Maneka Gandhi case, as well as a complicated interpretation of that right, is an example of the court creating new rights. But more recently, I think many of you would have read that the court announced a new right to privacy, and a very broad and substantive right to privacy. Please note that there is nothing in the Constitution, either in 19 or in 21, that expressly uses the language of privacy. So this is a judicial creation that has created a new right. And you might ask, where did it come from? The court found that the privacy right was embedded in Article 21, which is the right to life and personal liberty, as well as Articles 14 and 19, the rights to equality and the rights to liberty. So we understand that the new rights that we might find in our Constitution are a result of judicial interpretation. But our court has been alive to this possibility and used it significantly. I'm going to close this session with a very brief outline of how fundamental rights may be enforced. Is it the responsibility of the state? Is it the responsibility of non-state actors? Can private citizens be made responsible for fundamental rights enforcement? And should it be enforced legally or should it be enforced politically? And so let's look at this briefly as we close this section. And we will explore these questions in greater detail in the case studies to follow in week 6 onwards. Now, we had noticed that Article 12 of the Constitution primarily imposes an obligation on the state, which includes the executive branch as well as the legislative branch of the union and state government, as well as local and other authorities, to be bound by fundamental rights. So we have no doubt in our minds that the state is bound, the state in all its manifestations. There is a question on the boundaries of what are local authorities, should courts be included in local authorities and so on, but no final decision. We would need to get into a lot more detail to understand that aspect of the Constitution. But what about the broader question? Can fundamental rights be enforced against private citizens? Is that possible? And it's clear that some provisions of the Constitution, Article 15(2), where we spoke about the removal of civil disabilities with respect to access to public spaces, as well as Article 17, similarly motivated by caste-related disabilities arising out of the practice of untouchability, clearly seem to affect private persons. Article 23 as well, which prohibits human trafficking and forced labor, is not specifically directed towards the state, so potentially applicable to private citizens. In a much more complicated way in subsequent cases, the court has applied various fundamental rights to be imposing obligations, interpreted these fundamental rights to be imposing obligations on private citizens. And this, in legal technical terms, is called a horizontal application. Now, while we will not spend too much time on the theory of vertical and horizontal application of fundamental rights in a course, in an introductory course like this, you would do well to look at a book like Fundamental Rights and Their Enforcement by Uday Raj Rai, which is a very careful analysis of this broad area of fundamental rights enforcement. So in this slide, we learn that fundamental rights claims are primarily enforced against the state and secondarily may be enforced against private citizens. What we must realize is that the way the wide array of rights and principles are enforced in the Constitution varies significantly between Part 3 and Part 4 of the Constitution, as well as Article 226, which details the role of the High Courts. So let me just start with Article 37, of which we have read various parts in this lecture so far. So Article 37, which is the gateway to Part 4 of the Constitution, makes it clear that the directive principles are not enforceable by any court, while at the same time being fundamental in the governance of the country and being a duty, a constitutional duty of legislators and the executive to implement these principles. So clearly the directive principles of state policy are meant to be politically enforced by the political branches of the government, and the courts, if at all they have a role, they have a secondary role. Fundamental rights, on the other hand, are fiercely guarded by the court, in particular the Supreme Court under Article 32, as well as the various high courts, every high court under Article 226. So these provisions are fiercely defended by the courts, and by this we mean, for the fundamental rights, the constitutional courts, the high courts, and the Supreme Court. If you have other constitutional rights, they are not, we talked about Article 300A, we talked about Articles 326, which dealt with your rights of election. Who will protect those rights? Primarily Article 226, the High Courts. Now, it may go up on appeal to the Supreme Court, but your primary port of call is the High Court of your respective state. So notice that while fundamental rights and constitutional rights are primarily enforced through legal means, the directive principles of state policy are primarily enforced through political means, not through legal means. So with that, we conclude this lecture, lecture 2 of week 5, and our preliminary introduction to constitutional fundamental rights. From week 6 onwards, we'll get into some very interesting cases, and I look forward to welcoming you back to discuss these cases and get a deeper understanding of the specific fundamental rights in the Constitution, like life, liberty, and equality. Thank you very much. Look forward to seeing you back next week.